afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting shortly. For those who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
All right. Welcome again, everyone. Thank you for joining us today. Today's talk is entitled Rescue Mechanisms for Financially Distressed Companies Facing Liquidation. My name is Hannah, and I'm a senior associate with the firm, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawing & Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises 22 lawyers and a support team of 19. Dato' Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-sized law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents both from the corporate and dispute resolution teams. And as you can see here, that there are 5 practice groups that we focus on. Today's talk is part of our firm's online talk series. By way of background, we have always been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. However, with the COVID-19 MCO last year, we have moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. As you can see here, these were our recent talks that we have held in the past. Today is our 23rd talk for this year. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce to you our speakers. Today, we will have two of them. The first is Raymond Ma. Raymond Ma is the managing partner of the firm and heads the litigation practice. His experience includes a variety of construction and land-related disputes. Oops. Next, we have Sebastien. Sebastien Liew is our associate in the dispute resolution department. He deals primarily in contentious corporate litigation and company law disputes. In this talk, Sebastien will start us off with an overview of corporate rescue mechanisms. He will then speak on judicial management orders. We will later have Raymond speak on schemes of arrangement and the restraining order available under the Companies Act. If you have any questions, please don't forget to type them in the Q&A chat box, and we will address them at the end of the talk. Without further ado, I will now pass the time to Sebastien.
Thank you, Hannah, for the introduction. My name is Sebastien Liew, and I'll be the first speaker for today's session. I will begin today's online talk by giving you an overview of corporate rescue mechanisms. What are corporate rescue mechanisms? Corporate rescue mechanisms are basically a restructuring effort designed to aid a financially distressed company and to preserve its status as a going concern. Going concern, for the benefit of those who are not too familiar with this term, means the ability to function in the foreseeable future or to remain operational. The rationale behind this is that a company may be more beneficial to its creditors in terms of value if it is preserved as a going concern and if the company is able to avoid liquidation. Adding on to what was said in my previous slide, in essence, the objectives of corporate rescue mechanisms is to ensure that a financially distressed company remains a going concern, for the rehabilitation of the debtor company, for the company to avoid liquidation or insolvency, and to reduce the number of cases where companies are wound up. In Malaysia, there are 3 corporate rescue mechanisms available to a financially distressed company that is facing insolvency or the threat of insolvency. These are judicial management, scheme of arrangement, corporate voluntary arrangement. The focus of today's online talk is on the first 2 rescue mechanisms, which are the scheme of arrangement and judicial management. In the interest of time, we decided to omit the corporate voluntary arrangement mechanism from today's talk, as it is only applicable to private companies with no security, charge, or undertaking to a company's assets, leaving it applicable to only a very limited pool of companies. Perhaps we may touch on corporate voluntary arrangement at a different talk. If you would like to know more about corporate voluntary arrangement, the relevant provisions under the Companies Act 2016 are found under sections 395 to 402 of the Companies Act. The relevant laws. The 3 rescue mechanism processes are governed by the Companies Act 2016, Companies Corporate Rescue Mechanisms, Rules 2018. Previously, under the Repealed Companies Act 1965, the main rescue process was the scheme of arrangement. This mechanism is still available to financially distressed companies under the Companies Act 2016. Relevant laws. The Company Act 2016 further introduced two additional restructuring mechanisms, namely the corporate voluntary arrangement and judicial management. These two mechanisms came into force on 1st of March 2018. As our moderator Hannah Patrick mentioned earlier, I will be speaking on the judicial management mechanism. My co-speaker, Mr. Raymond will be speaking on the scheme of arrangement mechanism. What is a judicial management order? An application for a judicial management order is an application for the appointment of a judicial manager. The management of the company will be placed under the court-appointed judicial manager. Therefore, once the judicial manager is appointed and the order has been granted, the judicial manager displaces the directors of the distressed company. The relevant provisions for an application for a judicial management order is made under sections 403 to 430 of the Companies Act 2016 and the corresponding Rules 9 to Rules 37 of the company's Corporate Rescue Mechanism Rules 2018. Who may apply for a judicial management order? Section 404 of the Companies Act 2016 provides that a judicial management application may be made to the court by either the company or a creditor of the company. If the company makes the judicial management application, it should be done via either a resolution by its directors or its members. Next. Who may be nominated as a judicial manager? Under Section 407 of the Companies Act 2016, it provides that the applicant of a judicial management order shall nominate an insolvency practitioner to act as a judicial manager. Insolvency practitioners are licensed and authorized to act on behalf of insolvent individuals, partnerships, or companies. One restriction is that the nominated person shall not be the auditor of the company. Section 407 sub 2 also provides that the court, on its own volition, may refuse the applicant's nominee and appoint another person who is an insolvency practitioner as the judicial manager. In the case of GPAC Holdings, the High Court held the power to refuse the nomination of the applicant under sections 407 sub 2 is from the express words of the subsection and from a natural and ordinary meaning of the words contained therein. It is within the discretion of the court, and this discretion is unfettered and may be exercised by the court when, for example, there are obvious issues of conflict of interest, biasness, and the fact that the nominee proposed is not qualified to act and is proven to the satisfaction of the court. These are, of course, only examples, and the court will, at the end of the day, decide each matter on a case-to-case basis. Next. What is the duration of a judicial management order? A judicial management order, if granted, shall remain in force for a period of 6 months from the date of making the order and not the date of filing the application, unless the judicial management is otherwise discharged. Once the court has granted the judicial management order, there are only 4 situations in which the judicial management order is capable of being discharged early. Other than the 4 situations envisaged by the Companies Act 2016, the judicial management order cannot be discharged or set aside. The 4 situations are: the first, if at the creditors' meeting, the judicial manager's proposal has not been approved by the creditor. The second situation, if the purpose of the judicial management has been successfully achieved. The third situation, if the purpose of the judicial management is incapable of achievement. And the fourth situation, if the company's affairs, business, and property are being or have been managed by the judicial manager in a manner which is or was unfairly prejudicial to the interests of its creditors or members. The period for the duration of a judicial management order may be extended for an additional 6 months on the application of the judicial manager. In total, a judicial management order may remain in force for a maximum period of 12 months. If extended, notice of the extension shall be given to all directors, all members, all creditors, and any person entitled to appoint a receiver or receiver and manager. Moving on, I will now give some background on moratoriums under a judicial management order. Moratoriums are an authorized period of delay to perform a legal obligation. In judicial management, it is to preserve the process. The first type of moratorium under a judicial management application is an interim moratorium on legal proceedings, which is automatically triggered upon filing the application. Section 410 of the Companies Act 2016 provides that during a moratorium, no resolution shall be passed or any order be made for the winding up of the company. No steps shall be taken to enforce any charge on or security over the company's assets or to repossess any goods in the company's possession. No legal proceedings shall be commenced, and any ongoing legal proceedings by creditors will be stayed. Next. Once the judicial management order is granted, the moratorium will remain in force and will be valid for a period of 6 months from the date of the judicial management order. The moratorium is maintained for up to an additional 6 months if there are any further extensions granted on the application of the judicial manager. In essence, the moratorium will be maintained for as long as the judicial management order is in force or throughout the duration of any extensions thereof. Next. Requirements for a judicial management order application. The requirements are both regulated by statutory provisions and case law. The first, the statutory requirements to obtain a judicial management order, is provided under Section 405 sub 1 of the Companies Act 2016. Under subsection 405 sub 1a, a judicial management order may be granted if the court is satisfied that the company is or will be unable to pay its debts. And under subsection 405 sub 1b, a judicial management order may be granted if the court considers that the making of the order would be likely to achieve one or more of the following purposes. The first purpose, the survival of the company or the whole or part of its undertaking as a going concern. The second purpose, the approval under section 366 of the compromise or arrangement between the company or any such persons as are mentioned in that section. And the third purpose, a more advantaged realization of the company's assets would be effected than on a winding up. In practice, the applicant, of course, needs to show or set out these statutory requirements in the affidavit in support of the judicial management order application. Next. Additional requirements as per case law. Aside from the statutory requirements listed out in my previous slide, there are additional requirements that should be considered. The High Court, in the case of re by axis, provided that the judicial management application should be supported by an affidavit affirmed by the nominated manager, an insolvency practitioner, or the nominated manager is encouraged to prepare an expert report to support the application to be appended to the applicant's affidavit. Wong Hock Chong JC also provided reasons for the nominated judicial manager to either affirm the affidavit in support of the application or to prepare an expert opinion to be appended to the applicant's affidavit. The learned judicial commissioner's reasons are as follows. The nominated manager is the mastermind behind the judicial management process. The nominated manager has the expertise to consider whether the proposal can achieve the survival and better realization objectives. The nominated manager is able to provide an objective view, and it is as much the nominated manager's application by virtue of his appointment as it is the applicant's application. We will now move on to the public interest exceptions. Under section 405 sub 5a, even if the applicant fails to meet the requirements as exemplified in my previous slides, or a secured creditor has opposed the judicial management order, the court, at its discretion, may still grant the judicial management order if the court considers that it is in the interest of the public to do so. A public interest element would override all checks and balances for granting a judicial management order. However, it is only granted in the most exceptional cases and interpreted restrictively. Typically, the court will determine or evaluate what will constitute a public interest element on a case-to-case basis. However, it is tried that general reasons are not exceptions under the public interest exception. Naturally, generic reasons associated with winding up, such as loss of employment and uncompleted contracts, do not fall within the meaning of public interest. I will echo the public interest example given in the case of Re by Axis, where in the case, the court held that a company who alone possesses the vaccine for the COVID-19 virus applies for a judicial management order. The court may, in such exceptional circumstances, consider that public interest requires such an order. I repeat, this is usually determined on a case-to-case basis. Once the court has granted a judicial management order, what happens next? Essentially, under Section 420 of the Companies Act 2016, it provides that within 60 days of the judicial management order, the judicial manager shall send his or her statements of proposals to the registrar, to all creditors at their last known address, to all members at their last known address, to publish in a widely circulated newspaper in the national language and in the English language. The statement of proposals of the judicial manager is the substantive consideration, basically on solvency and achieving survival or better realization of the company assets in comparison to being wound up. This should be formulated at the preparation stage of the application prior to the judicial management order being granted. Once the statement of proposal is ready and sent out, the judicial manager may call a meeting of creditors to table and vote on the same. A meeting of creditors shall be summoned for the period of not less than 14 days notice. Basically, this means that the creditor must be notified 14 days before the actual meeting is held. At the actual meeting, the creditors will decide whether to approve or to reject the proposal. The requirements is that there is an approval of 75% of the creditors in value, in person or by proxy, present and voting. If this requirement is met, this shall bind all creditors. I emphasize that 75% of creditors present and voting must approve the proposal. Once the manager's proposal is approved or accepted, the proposal shall be executed within 6 months from the date of the judicial management order was granted, and not from the date of the creditor's approval or the date of the meeting. Next. Who may intervene in and oppose a judicial management proceedings? Under Section 409 of the Companies Act 2016, it suggests that only secured creditors may oppose the making of a judicial management order. Similarly, under Rule 13 of the Company's Corporate Rescue Mechanism Rules 2018, reference is specifically made to secured creditors appearing and opposing the hearing of an application for a judicial management order. To appear at the judicial management hearing and to oppose the application, a secured creditor must serve a notice of intention to appear on the applicant and or on the applicant's solicitor. A notice of intention is a document filed in court stating a party's intention to be involved in a proceedings. Next. Contrary to what appeared to be the settled position as per my previous slide, where only secured creditors may intervene, recent case law suggests that unsecured creditors may have the locus standi to intervene and to oppose in judicial management proceedings. The applicants in the GoldPage case submitted that the creditors who had applied to intervene in the judicial management proceedings had no locus standi as they were unsecured. The court held that sections 404, 405, and 409 do not specify that an unsecured creditor cannot take part in the hearing or to oppose in such proceedings. The court held that section 409 only makes it compulsory for the court to dismiss an application if a secured creditor opposing has or will appoint a receiver or receiver and manager. The GoldPage asset case makes reference to the Hansard, also known as the official parliamentary debates, and the explanatory part of the statement of the bill. It found that these documents do not reveal any intention by Parliament to restrict unsecured creditors. Further, the court found that Rule 13 of the rules must also be read in conjunction with its parent act, the Companies Act 2016, and the act does not prohibit any creditor from hearing or opposing such proceedings. In essence, the rules cannot contravene the parent act. Next. In the Million Westling case, the unsecured creditor had applied to intervene. Asmin Arifin J had interpreted the law differently from Nazarin Wok JC in the Gold Page case. In dismissing the application to intervene, the learned judge held that Order 15, Rule 6 of the Rules of Court, which is for misjoinder or for persons to be added as a party, the judge held that Order 15, Rule 6 does not apply to a judicial management application. The right to oppose has been provided clearly in Rule 13 of the rules, read with sections 408 and 409 of the Parent Act, which specifically refer only to secured creditors and debenture holders. However, on appeal, the High Court's decision was overturned and the Gold Page asset case, as per my previous slide, was followed by the Court of Appeal. Leave to appeal to the Federal Court has been granted, and we await the Federal Court's decision to clarify on whether unsecured creditors may intervene in judicial management proceeding. This marks the end of my talk on judicial management. Thank you for listening. I will now pass the floor over to my co-speaker, Mr. Raymond, who will be speaking to you on schemes of arrangement and restraining orders. Thank you.
Thank you very much, Sebastien, for covering the first section of our talk, and thank you, Hannah, for the introduction earlier. Good afternoon, everybody. And just give me a moment to get my slides up on screen. All right, Sebastien, does that work? Okay, good. In my section of the talk, I will cover the key points on the scheme of arrangement and restraining orders. What is a scheme of arrangement under Section 366 of the Companies Act? And the definition is here. It is a court-approved process whereby an agreement between a company and its direct creditors is reached to aid the company in fulfilling its debt obligations. The application for the scheme of arrangement is made under Section 366, and the application for a restraining order under Section 368. The SOA, or the scheme of arrangement, differs from a judicial management order that was covered by Sebastien because the company remains in control of its management. However, the scheme is still subject to the supervision and sanction of the court, as we will discuss in greater detail in the minutes ahead. The objectives of the scheme of arrangement are essentially to help a company that is in financial trouble. But I've set out here 3 key points, which is firstly to revive a financially distressed company as a going concern. So it still has to be a going concern. Number 2, to avoid the prospect of liquidation and to restrain proceeding against an insolvent or barely solvent company. This would be the company in trouble. And thirdly, to secure the payment of the creditors' debts or secure better repayment as an alternative to the company being wound up. These are the 3 key stages of a scheme of arrangement. We generally call them the first stage being the convening stage, the second stage being the meeting stage, and the third being the sanction stage. Either it's a company, a creditor, or a member of the company, the liquidator, if the company is being wound up already, and the judicial manager, if the company is already under judicial manager, may make this application under 3661 of the Companies Act. Some examples of the jurisdiction questions for the court to consider at the first stage, which is the convening stage, which is made by an originating summons pursuant to 366. Number 1, the court will consider the formulation or composition of the different classes to determine if the proposed scheme meets the definition of a compromise or arrangement, and then to determine whether the company is so hopelessly insolvent to survive a post-scheme as a going concern. If there really is no hope to rehabilitate the company, then the court can exercise its jurisdiction to refuse leave at this stage. And finally, to give the appropriate directions for the convening of the meeting. When it comes to item 1, the formulation and composition of the classes, what arose in the Air Asia Acts case was litigation and disputes over how the different creditors should be classified into different classes. And the court did find that different creditors with different rights can be categorized into different classes if it doesn't make sense for them to be categorized together in the same class. As to the method for the originating summons, it has been held in this Sri Hartamas development case that the application is to be made ex parte. We also have the more recent federal court case in Mansion Properties, where a challenge was taken up on this point, even though the practice has always been to make the applicant ex parte. The question was tested on appeal to the federal court, and the federal court has held that the proper mode to make the application is to make it ex parte. And what ex parte means is that the company is the sole applicant and there's nobody there to oppose it, not the creditors included. It is only later, when the order is served on interested parties, including the creditors, that they can then intervene and perhaps to set aside the order if there are grounds to do so. Between the first and second stage, the convening stage and the meeting stage, there is this negotiation phase which can occur. And once leave is obtained to convene the meeting, the company will then proceed to identify the creditors and to determine the quantum of the debts owed to each creditor and to the different classes of creditors. And then to continue engagement with the creditors to negotiate on the terms of the scheme that is being proposed by the financial advisors or the company, with the objective to achieve the best terms to secure the approvals from the necessary, which is 75% of the creditors from each class, to meet the threshold for the sanction from the court. So at this stage, the company has to engage with its creditors and basically negotiate successfully and gain the support of at least 75% of the creditors to move on to the next phase. When the company is confident that it has that support, it moves on to then the meeting stage, stage 2. And here the scheme is presented at the meeting or the meetings which are held in accordance with the court orders that were given at stage 1 at the convening stage. As I mentioned earlier, the proposed scheme has to be approved by a majority of 75% of the total value of creditors present and voting, either in person or by proxy, or at the subsequently adjourned meeting. And as I mentioned earlier, the approval must be by a majority of 75% of the creditors in each class. The applicant will have to comply with all advertisement requirements, advertisement and service requirements pursuant to section 366 and 369 prior to the meeting to give notice to all the creditors. And these are the things that have to be complied with, including the service of proxy forms to the correct addresses and publishing the creditors meeting in the English newspaper and in the Malay language. Meeting can be adjourned, provided again that there is a resolution for adjournment by at least 75% of the creditors in each class present and voting. At the third stage, once the resolutions are once the scheme has been approved by a majority of creditors, the next stage is to take it to court for the court to sanction what has been approved by the creditors. And only upon the applicant or the company obtaining the sanction from the court will the compromise or arrangement become binding on the company and all its classes of creditors, including the minorities who may have opposed the scheme. The courts have also held that third parties can be involved in the scheme that's proposed and can also be similarly bound in a statutory contract, so to speak. When does the order take effect? According to section 366 sub 5, an order for the compromise or arrangement shall have no effect until the copy is lodged with the registrar and shall take effect on the date of lodgement or as an earlier date as the court may define or specify in the order. Now, what are the principles that the court will consider at the sanction stage? These are the principles which are set out here, 4 key principles. But essentially, the role of the court at this stage is not to second guess the majority of the creditors. It's not to impose its view or its opinion on what would be the best outcome for the company or the creditors, or to make an opinion on whether what has been proposed and approved is commercially viable or not. Really, the court's role here is to check and see whether the provisions of the statute have been complied with. Number one, whether the class was fairly represented at the meeting, whether there was any coercion by the majority on the minority, whether the scheme was fair, and one that a creditor could reasonably approve. And then lastly, whether there's any plot or technical defects in the scheme. As I said earlier, the court will be very slow to defer from the meeting unless any of these requirements are satisfied. And once the as I mentioned earlier, once the scheme is approved, it will be binding on the minority, even if they may have opposed the scheme. As far as restraining orders are concerned, this application is made under 368 of the Companies Act. And unlike a judicial management order or a corporate voluntary arrangement, a scheme of arrangement in itself does not trigger a moratorium in the sense that there is no automatic stay on creditor enforcement and legal proceedings against the company. And an application has to be specifically made either together or separately under 368 to ensure that the company's restructuring efforts are not rendered nugatory pending the approval and disposal of the scheme of arrangements. In this case of Mason Properties, the federal court made it quite clear that the purpose of the application under 3681 is to preserve the status quo and to prevent efforts to develop and improve a scheme of arrangement from being thwarted by the dissipation of the company's assets. And in light of the potential necessity for immediate action and speedy resolutions, an ex parte applications would be suitable and be appropriate to achieve the legislative purpose, which is to give the company a full opportunity to reach the scheme of arrangement. Just a point to note is that while the restraining order does restrain proceedings against the company, it does not restrain the company from initiating proceedings against third parties. Under Section 3682 of the Companies Act, the period is set out as to how long the restraining order remains in force. The initial restraining order is valid for a maximum of 3 months, and this can be extended up to a further of 9 months only. In subsection 2, the preconditions for the granting of a restraining order are set out, and these are firstly that there is a proposal for a scheme of arrangement. Secondly, that the restraining order is necessary to enable the company and its creditors to formalize the scheme for approval. Thirdly, that a statement of particulars as to the affairs of the company is lodged together with the application. And lastly, that the company approves or appoints a person nominated by the majority of creditors to act as a director. Now, in this case, in the case of Baccarat Offshore, there was a dispute or an issue as to whether all 4 sub-paragraphs which I have just gone through, let's go back one slide, all these 4 sub-paragraphs in sub-paragraphs A to D of 368 sub 2 were to apply in respect of the initial restraining order or in respect of the extension only. And the argument there was taken was that, well, even if we didn't comply, it was not necessary to comply with all 4 for the initial order, but only as to the extension. And the High Court, in this case of Baccarat Offshore Petroleum, shot down that argument and on its interpretations that all 4 need to be complied with, even in the initial restraining order. Okay. Here are some other statutory conditions which will be considered by the court. The person approved by the court has the right to all of the company's records and is entitled to require any information from the company as required. Secondly, and unless the court orders otherwise, any disposition or acquisition of company property other than in the ordinary course of business made after the grant of the restraining order is void. and this constitutes an offense. And lastly, when a restraining order is granted, the company shall lodge a copy of that order with the registrar and publish a notice of the order in a widely circulated paper. Okay, that concludes my section. Perhaps now we can move on back to you, Hannah, for the question and answer section.
That's right. All right, just give me a moment to navigate the questions. Right, so I will have both Sebastien and Raymond on standby to answer the questions. All right, okay. The first question we have, what happens under this arrangement? And I'm assuming this question is with regards to judicial management. Okay, so what happens under this arrangement in terms of daily management decisions? Does the JM, the judicial manager, need to approve them? I'll hand this over to Sebastien. Sebastien, can you answer this?
Yeah, sure, Hannah. In short, the judicial manager will assume the duties of the board of directors. The powers and the duties imposed on the directors by the Companies Act or by the articles or the constitution of the company shall be exercised and performed by the judicial manager and not by the directors. If there are any uncertainties, the judicial manager can apply to court for direction. This is under sections 414 sub 2 of the Companies Act.
Okay. All right, I will move on to the next question. Thanks, Sebastien, for that answer. Under this scheme, now this one I would assume it's the scheme of arrangement, SOA. Under the scheme, does 75% of all class of creditors have to vote in favor of the scheme or just the majority of the classes? Raymond, would you be able to take this?
Sure, Hannah. The answer is yes, 75% of all classes, each class present and voting. So if there are two classes even, and there's majority in one class but not the other, then the scheme of arrangement will not pass.
Thank you. Thank you for that. All right, let me see if there are more. How long is the maximum restraining order period? 9 or 12 months? Raymond? Okay.
It's 3 plus 9. So 9 would be the maximum in terms of a extension, Hannah.
Thank you.
And so the total 3 plus 9 would be 12 months.
All right. Let me just check if there are more questions in the chat. Okay. There are no more questions unless there's anything to add. Oh, wait. Okay, I do see one. Just give me a moment. This is a question from Irene Zainuddin. Under the scheme and the RO, which is the restraining order, what happens if within 12 months the company couldn't get 75% votes from the creditors? Who will be able to answer this?
Irene, the votes and the majority amounting to 75% of each creditor's class has to happen after stage 1, which is the convening stage. If at the meeting, the company cannot obtain 75% majority from each class, then the scheme of arrangement will not go into effect. And I suppose if by that time the restraining order expires, then really too bad. Sebastien, do you have anything to add to that?
No, that's correct.
All right. Okay, I'm just skimming through again, everyone, and I don't see any more questions. But if you do have questions, in the future after you have probably reviewed the slides or watched our video again, please do consult us. I will give you our details much later. But let me just,
Hannah,
yes?
There's one question here on the AirAsia X case.
Right, okay. Would you be able
Well,
to
I
take
will
that?
hesitate to answer this question. It's a very long an in-depth discussion by the court, some 96 pages of the written judgment, but I'll see if I can summarize it in just a minute or two. Now, of course, AirAsia Acts is, a name that is known to all of us. And what happened here is because of COVID-19, the company found itself in a position where it had to apply for a scheme of arrangement. And the real issue here in the decision by the court in allowing the scheme of arrangement was whether the creditors, and I think it was the leasing company on the one hand and the general creditors on the other, whether they would fall into the same category of same class of creditors. And then in that case, from my recollection, the court held that, well, given the differences in the agreements between the aircraft leasing company as opposed to the other creditors, the court held that it was appropriate, looking at the differences in rights, to put them into different classes of creditors. And in that case, ultimately, the scheme of arrangement was allowed. Sebastien, do you have anything to add from that, from what you can recall from reading that case?
No, I think you summarized it quite well.
Thank you.
Okay. There are two more questions. If we do have a bit more time, would anyone be? I will ask them. Okay. All right. One here would be from Datoma himself. Say, can AAX, which is Asia X, make further payments to air travel consumers beyond the terms of the scheme? Anyone? Or would you need?
I think that would be a difficult question to answer at this stage. I think to answer that question, we really need to go into the details of the AAX scheme of arrangement. I don't think I can answer that.
At this point. Yeah.
Yes.
Yes. Okay. No worries. One more question, and this will be the last one. Okay. Why would a creditor accept 0.05%? I do not know the context of this question, but maybe if any of the panelists be able to hazard an answer. Why would a creditor accept 0.05%? Maybe Mr. Han Lo, would you be able to elaborate on your question? You can just type it in the chat.
Okay. As Hannah said, I don't think we're too clear on the context of that question. I would also ask, why would a creditor accept 0.05%? So it depends on the terms of the scheme. And it's really up to the company and the financial advisors to come up with a scheme that the company thinks will be acceptable to a majority of the creditors. Now, the schemes can vary very significantly. So, for example, in the AirAsia Acts case, what I do recall from the case is that there was a substantial haircut in terms of the amount that was proposed to be paid to the creditors. I think they're only going to pay 200 million in settlement of the outstanding debts. But in other cases that we have seen, the proposal is made to pay the debts in full, but over a period of time. So the company is then given time to settle the debts in full. So yeah, it really is up to the company. And I don't think that any company that's offering to settle 0.05 of his debt, so it's going to get his scheme approved by a majority of creditors. So really it's about coming up with a scheme which is acceptable to the majority of the creditors.
Thank you. Thank you. All right. I do see a comment there for us to hold one day a webinar specifically on AirAsia X restructuring. Thank you for the suggestion. We will probably take it into consideration, Mr. or Ms. Chan Chai. Okay. Well, that wraps up the talk today. Let me just give some closing remarks, if I may. Just give me a moment to share my screen. right. So thank you, Sebastien and Raymond, for your insights.
Thank you, Hannah, for moderating today's session.
Certainly very insightful, and I see the participants appreciate that as well, right? Now, before we conclude, here is an announcement of our upcoming talk. We have 2 in December. No rest for the team, I guess. So we have one on Islamic estate planning versus civil law estate planning. And this is where you are able to get insight from 2 teams, which is the Sharia team as well as the estate team, where they will be able to give you an insight into the differences between the 2 estate planning. And the next talk on the 15th of December is on informed consent and claims for unauthorized medical treatment. These are for people who are interested in medical law and medical matters. And this will be delivered by 2 of our young associates, Ms. Fung Carmen and Ash. So you can sign up by scanning this QR code or visit the link. So I will put up this slide for a little longer for you to be able to scan the QR. Otherwise, you can just visit our website with the link there. Okay. All right. Next, someone from our team will in a short period of time give us the link for the feedback form. So please fill in our feedback form and tell us what you think of our talk today. And the link is the link is up in the chat box. So Ms. Chan Chai would really appreciate if you can just copy your comment and paste it in the form so that we'll be able to access your comment again. We will look into this. All right, so that's the link there. Third, if you're on social media, please do follow us. We're on YouTube, Twitter, Instagram, LinkedIn, and Facebook. We're on all platforms, so that you will be able to access our content over there as well. And if you would like to speak with our lawyer, just give me a moment. Okay, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form by going into the link or scanning the QR code here as well. Again, I'll leave this for a little longer for you to be able to scan it. Okay. So if you have more questions on what was said earlier, please do not hesitate to contact us. All right. So to everyone, thank you again for joining us. We hope you found today's session informative and useful. I would like, typically we would take a photo, in the old format, but not today. That's fine. I'll just stop sharing. So I hope that you'll be able to learn something today. And thank you everyone for joining. Thank you.
Thank you, ladies and gentlemen. And